Hi everyone, this is my very first Facebook Live video. Actually it's not, it's actually my 10th or 11th one. The first 10 I was testing out just to see what I could do, just to check the mechanics of how to actually go ahead and shoot some Facebook Live video. Alright, so I want to welcome you here to my show called Objection! Don't answer that question! For those of you who want to know what this video is about, it's about real lawyers, real cases, and real results. That's what this case is about. That's what this video is about. That's what this show is about. Real lawyers, real cases, real results. It's better than any reality show you're going to see. Why? Because I'm going to take you inside the look of real trials. I'm going to interview different attorneys to show you the actual drama that occurs when an attorney is questioning a witness. I'm going to show you what happens and reach that pivotal moment to go ahead and show you exactly what happens here. So one of the things that I want to do here is, during the course of my video, you're going to see questions, you're going to see answers, you're going to see drama in the form of transcripts. So I'm going to be interviewing different attorneys right here on I'm going to be interviewing attorneys who are going to be showing you actual transcripts, and we're going to have a bit of role play. The role play will be question and answer. The attorney will be questioning as if he's at trial. I'll be the witness who's going to go ahead and be reading parts of the transcript. Transcript that's going to give you information about the issue in the case. So remember, this is going to be objection. Don't answer that question. Hey, Steve, how are you? Nice to see you. One of the great things about this type of video is that it allows you, the user, to go ahead and interact with me. And that's the great thing, because this way you'll get to see an attorney in action. Most of us never get to see an attorney in action unless we're watching a TV show, unless we're watching a movie. Well, here you'll get to recreate in your own mind exactly what happened during the pivotal scene, the pivotal moment where you have a witness that's being cross-examined, or now there's an issue in the case. And guess what? During the course of questioning, you're going to reach that pinnacle where you're going to know exactly where the issue is. You're going to feel the tension, and the tension is going to show up in the form of questioning. Now, you should know that in a trial, whether it's a medical malpractice trial, an accident trial, or any type of accident trial, you should know that cross-examination is the most important, the most dramatic moment that occurs. And everybody, hey, thanks so much for the like, I appreciate it. Everybody realizes that if you can catch a witness in a lie, guess what? Now you've made your point. If you can catch a witness in a contradiction, again, you've made your point. That's one of the key things about trial that makes it so interesting. So if you've never had a chance to watch, this is an opportunity to participate in watching something that's actually dramatic. Now, in my very first video today, I'm not going to be having let me go back. My very first video today is going to be a format that's basically going to show you a scene in a trial that I handled a long time ago. And then, going forward, I'm going to be interviewing different attorneys so that they can show you, and so that I can highlight what they've done. And then I'm going to stop them. And by the way, I want you to stop them. I want you to interject, and I want you to raise your hand and say, objection! Don't answer that question! Why? Because you can sense, you know when a question is improper. You know when a question shouldn't be asked. And that's your job. So your job is to actively participate in this show so that you can actually see what goes on. You can interject, hey, thanks so much for the like, I really appreciate it. So that you can actually see what's going on as you go forward during the course of trial. And this way you get to participate. Thanks so much for the like, it's great. This is wonderful. So one of the things that we're going to do this morning, as I'm shooting this video live, is I'm going to take you through a case that I handled a number of years ago. And you should know that I'm a plaintiff's attorney, which means I represent injured victims, people who are involved in accident cases or medical malpractice cases. Thanks so much for the like. I really appreciate it. But this case that I'm going to be talking about in just a moment involved a case where I was a defense lawyer where I was representing an owner of a resort in upstate New York. So now, in every show where we have attorneys on this show talking about real cases, real people, and real results, we're going to be setting the scene. I'm going to be explaining to you, and I'm going to have the attorney explain to you exactly what the case is about in a short summary. And then we're going to delve right into the key issues in the case. And by the way, you should know, I'm going to stop the attorney to ask them questions. And I want you to ask questions also, because that's so important. It's so critical to have you ask questions. Like, why did you ask that question? Why was that an important strategy? Why did you do this? Now we have an opportunity to engage with you and to actually explain why an attorney was asking a series of questions. So I'll give you a great example. Why does an attorney ask leading questions when they're cross-examining a particular witness? And by the way, I'm just going to grab some water, so hang on 1 second. All right, so I'm back with some water. One of the things that people have questions about is, why do you do certain things during the course of trial? That figures. All right, so one of the things that we are going to do is have you engage in the attorney's questioning, have you engage in our discussion so that you can actually ask, why did you do that? Why was that necessary? Why was that important? So this case that I'm talking about goes back 26 years. I've been in practice more than 28 years now here in New York. And this case goes back 26 years. I was shocked to see the actual date of the transcript. Okay, this is a transcript, which is a booklet of the questions and answers that are given during the course of pretrial testimony as well as during the course of trial. And it just so happens that this booklet was done May 23rd and 25th of 1990, where it took place in the Supreme Court of the State of New York in the county of Nassau, specifically in Mineola. This was a case where I was a defense attorney. I was representing a winter resort. And this was a very interesting case. I'm in practice just 2 years at this point. And my boss says, you know what? Go try this case. So here I am, this young, new attorney trying cases. And I actually drove up for 3.5 hours it took me to get to this particular resort in upstate New York. And why would I do that? Because I wanted to see where this accident happened. I wanted to learn everything I could about how this accident happened. So this particular case was a sledding accident case. And the person who was on a sled got severely injured. And now he was bringing a lawsuit against the resort, claiming that the resort was careless, they were negligent. And one of the things that I was supposed to do is to defend the resort to show that we were not legally responsible. Now you might be thinking that a resort area is always responsible for the actions that go on by their guests. Well, not exactly. And I'll tell you why in just a moment. So here I am driving 3.5 hours to go. Welcome, thank you so much for joining me. That's wonderful. One of the things that I did was I now met with the owners and I had him walk me over to the area where this accident occurred. And now I had him show me the area. Now you should know that I went up in the middle of the summer, in the summertime. Now the conditions were totally different than in the wintertime when this particular accident occurred. But I still needed to visualize exactly where it happened so I'd have a clear understanding. So I could question this injured patient, this injured victim, at the appropriate time so that I'd have a better knowledge of the location, of the signage, of the area in relation to where things were. And that's why you'll find that the best trial attorneys are the ones who actually go to the scene of an accident at some point, the ones who go and learn hands-on so they can see for themselves, not just rely on pictures, not just rely on a book or a text or something else. You've got to go to the scene. And that's one of the things that my boss, as a defense attorney, imparted to me, that you've got to go to the scene. So here's the scene. It's a gorgeous, beautiful area up in the mountains in upstate New York. Beautiful rolling hills. Gorgeous, gorgeous property. This property is amazing. Okay, you can do every type of winter activity possible. The air is clean, you can smell it, you can feel it. And now it turns out that this couple, this young couple, had gone up there for a winter vacation for a weekend. And now you have these young people, I shouldn't say young, they're in their early 30s. early 30s. So they're in their early 30s. They're in their early 30s, and they decide that they actually want to do some winter activities. So what do? They decide they're going to go sledding. Now, they're looking around for sleds, and this guy happens to see, the 6-foot guy, 180 pounds, happens to see a sled sitting across. No, let me go back. This guy sees a sled leaning up against one of the buildings nearby. And this sled is not a regular sled. What is it? It's a round disc. We'd call it a flying saucer. Thanks so much for joining me. I appreciate it. It's a flying saucer. And what does he do? Remember, you should know that a flying saucer has no handles. It has no way to steer. All it has is something to hold on to on the side so that now you get on it and you go. And one of the things about this flying saucer is that it continues to spin around. You have absolutely no control. So he takes this particular flying saucer and he grabs it, and they go running up the hill. And now the intention was they're going to take this flying saucer and now go sliding down the hill, right? As kids, you do that all the time. Our kids do that all the time. It snows? Great. Let's go out to the sledding hill, grab your sled, and now start going down. All right. Well, feel free at any time to yell out, "Objection! Don't answer that question." Because the moment you do that, then I'm going to stop. You post your question. I'll try and answer the question as I'm going through this. So, here's what happened. He goes up to the top of the hill. He gets this big 6-foot guy on this kid's flying saucer sled. And now he goes. And what do you think happens when you go? Well, exactly what it's designed to do. It's a disc. It's a curved disc. And now he starts spinning around. Well, for him, he was spinning around, and now he's going down backwards. He can't see what's behind him. Thanks so much for the heart. I love that. This is great. So he's going down backwards. And as he's going down backwards, he can't see anything behind him. All he knows is that he's building up speed. He's building up steam. So what happens here? Well, what happens here is that as he gets close to the bottom, all of a sudden he hits something hard. And now as he hits something hard, boom, he goes flying up and then lands on his tailbone, on his coccyx. And he suffers an injury. He fractures his tailbone. And now he's out of commission and he needs to go to the hospital, and they work him up in the emergency room. But you know something? Even though you have a fractured tailbone, there's no treatment for that. None. So let's fast forward a bit. So this guy decides, you know what? Hey, I'm not responsible for my own injury, even though I hopped on a sled, even though I hopped on kid's sled, kid's device. Guess what? Michael, how are you? Nice to see you. This is a great live video, and I'm going ahead. My show is called Objection. Don't answer that question. That's a great thing that I'm doing right now, and I'm going to have a series of interviews with attorneys talking about cases that they've handled and talking about the dramatic moments that they've encountered during the course of trial. And we'll actually be recreating actual trial events using transcripts, trial transcripts, and deposition transcripts. So, Michael, thanks so much. I really appreciate your comments. So now you know the scene. The scene was, you have a young guy with his wife and another couple. They decide to go sledding. They grab a sled. They start going down the hill. This guy spins around. He hits something at the bottom, and now he fractures his tailbone. Okay, and now he decides to sue this resort, saying that they were careless, saying that they were negligent. Were they really? What do you think? Were they careless for allowing this guy to go down the sled, for having sleds around the area? There were no signs saying, sledding, you can pick up your sleds over here. They didn't rent out sleds. This family, this guy decided, hey, I'm going to take a sled, go down the hill, and see what happens. And you know what? If he hadn't hit this thing below, maybe none of this would have happened. And you might be asking yourself, what was it that he hit at the bottom? It turns out that when I went up there during the middle of the summer, I was able to actually visualize exactly what he likely hit. And what he hit was a railroad tie. You see, that railroad tie bordered a roadway. And that roadway was just one area that led to the bottom of a hill. Now, hey Nancy, how are you? Nice to see you. Thanks so much for joining me today. Nancy, in case you don't know, this show is called Objection, Don't Answer That Question. And it's about real cases, real attorneys, and real results. Better than any reality show. So what we're doing here is trying to explain and using real cases to highlight different events that occur during the course of trial, during cross-examination, during openings, during closing remarks. Stuff that you don't see except if you're actually at trial. You don't see it unless you're watching a movie about a courtroom drama or about a TV show. But here we are using real cases, real attorneys, and real results. And by the way, you're encouraged to actually go ahead and tell me your objection or ask questions about why we're asking a question or why a strategy is being implemented. So feel free to raise an objection. Feel free to ask a question, because that's going to make it more interactive. That's going to make it more exciting for you, Nancy, and for you, Michael, and everybody else who's watching, even if you're watching the replay. So let me just grab a sip of water here. All right. So now we've set the scene. So let me take you into my closing arguments that I made in May of 1990. I can't believe I found this transcript going back 26 years. No, yeah, 26 and a half years ago. That's crazy. I was in practice just 2 years as a defense attorney. So here we go. I'm going to be reading from the transcript. And when I say reading, I'm going to try and recreate as best I can using the intonation, using the feelings and the emotion that as I'm giving this particular closing argument to the jury in Mineola in Nassau County 26 years ago, I want you to get the feeling of what it's like to be in the courtroom so that you get to understand exactly what's going through my mind, exactly what has happened in the courtroom, and importantly, you'll get to hear pieces of the evidence to show why we believe we're entitled to a verdict in our favor. And after I'm done with that, then I'm going to share with you exactly what the verdict was in this case. Okay? So here we go. Thank you, Your Honor. May it please the court, counsel, members of the jury. Winterclove, this was the resort, by the way, where I actually went ahead and represented. Hey, Rob, how are you? Nice to see you. Winterclove is a beautiful country inn situated in northern Catskills. It's a place you go to get away from it all. Now, I wanted to give the jury the recognition and the understanding, since they couldn't actually go to this resort 3.5 hours away. I wanted them to feel in their own mind exactly what it was like to be there. Andy, how are you? Nice to see you. Say hello to everybody for me. I'm so glad you could join me today. And in today's video, and again, I'm just going to backtrack for a moment. This is the very first video of my show called Objection, Don't Answer That Question. And the whole purpose of today's video is to explain to you about real cases, real lawyers, and real results. It's better than any reality show you're going to watch. So now come join me as I've already set the scene for what's going on here. I represented many years ago, I was a defense attorney, and I was representing a resort up in the Catskills, up in the mountains here in New York, against a guy who was on a sled and suffered an accident. He fractured his tailbone. And he brought a lawsuit against the resort. So now I'm going to read to you pieces of closing argument that I made to this jury in Nassau County in Mineola to give you a sense of what it was like. Because, hey, Joe, nice to see you. How are you? Oh, my good friend Joe Zoma. I'm so glad you're with us today. So this way you get a sense of what it's like to be there, and you get to feel the drama and the tension. And this way, this is better than any TV show or courtroom drama. Here you get to read about it, actual real cases. All right? So let's get going. All right. It's a place to go to relax and to just wind down, to enjoy the scenery, enjoy nature as it is. Plus, it affords the ability to engage in activities, depending upon the season, whatever winter activities, spring activities. Hey, Michael, nice to see you. Thanks for joining us. Summer activities, nice country setting. Now, Winterclove has been around since the 1800s, run by the same family. Michael, this is a great show for you to watch. I'm glad you're here, and it's going to show you real cases, real results, and real attorneys. So now, I tell the jury, this is a simple case. Why? Because I don't want them to overcomplicate things. I want them to understand this is a simple fact pattern. Okay, now here it is. It's a case involving a single person on a single day. It's a case about someone's negligence. It's a case about being reckless in your own conduct. It's about that man over there doing something at his own risk and disregarding the dangers that go along with the activities that he did. This is a case about an incident that happened in 1984 in January on a particular day. Plaintiff and his wife were going up to Winterclove, driving up from Long Island, presumably with their friends, and they had intended to go ice skating. Thanks so much for the like. We'll show you that he took his ice skates up. They intended to go tobogganing, intended to go hiking up the mountain. Now, as soon as they get there, they check in. They ask if there's time to go sledding before dinner, and someone tells them yes. So they go back to their room and they change and they run out to the first hill they see. Thanks so much for the like. Danny, how are you? Nice to see you. Thanks for joining us. But wait, before I get to that point, look at that. Yes, I love those emojis. Before I get to that point, after they got to their room, the judge has told you, we do not have to prove anything in this case. Now that's a really important point for the jury to understand. They need to know that we as the defense don't have to prove anything. Instead, it is the plaintiff, the person bringing the lawsuit, who has to show that they are more likely right than wrong. That's known as the burden of proof. So that's a requirement. And if they can't show that they are more likely right than wrong, guess what? Case is over. We don't actually have to show or prove anything. Now I needed to tell the jury that, and that's exactly what I did. Now, I go on and I say, listen, it's the plaintiff's obligation to prove his case to you. The plaintiff is the injured victim and his attorney. And if he doesn't prove it, I will certainly prove it. Now, after leaving their room, taking the toboggan with them, they go in search of another sled because maybe they have some friends with them. They're going for another sled. The plaintiff, Mr. Boscano, comes upon a sled. This flying saucer, this piece of plastic round dish that he sees lying on a porch. It's not his porch at all. He goes up to the porch, and what does he do? He takes it. He doesn't ask anybody. He doesn't knock on the door. He just takes it. Then the four of them, the plaintiff, his wife, and their friends, go traipsing up the first hill they see. Oh, and mind you, I presume that there will be testimony that, objection! The plaintiff's attorney yells out. Here we go. Mr. Jacobs is the plaintiff's attorney, and he yells out, objection! What's he objecting to? He's objecting, he says, object to what he presumes. I have no objection to him telling the jury what he intends to prove. Well, now I respond. We will show that the plaintiff you know what? Here's something that I didn't realize. This was opening remarks that I'm reading to you, not the closing. I have the closing at the other end of the transcript. But this is okay because you get to see exactly the strategy that I'm trying to use in the beginning of the trial. So, I now get the objection from the attorney. I now change my wording a little bit, and here's what I say. We will show that the plaintiff apparently asked somebody where to go sledding that day. A mystery man. And I don't know how to defend against a mystery man. And now the plaintiff's attorney again yells out, objection! I object to this! And he starts to argue. You should know. Hey, how are you? Thanks so much for joining. It is improper. No, I shouldn't say improper. It is not customary to make objections during opening remarks or closing remarks. Customarily, attorneys give each other a lot of leeway during the openings and closing remarks. Why is that? It's because it's an opportunity for us to tell the jury what we're going to show, what proof we're going to show, what the evidence is going to show. And in closing remarks, it's our opportunity to have the jury understand what the evidence was and to show that we deserve a verdict in our favor. All right, so now the court gets upset, and you're going to love this. He says, stop, stop, stop. Thank you, you made your objection. If I need help, I'll ask you the reason for it. So he's telling the plaintiff's attorney, stop talking. Don't make objections that have reasons or explanations. Just stop. Make your objection. Counsel, let's stay to the opening and not anything that sounds like summation. So now he's directing his objection or his comment to me, where he doesn't want me making summations or reaching conclusions at this point. That's fair. So rather, what is it that you intend to prove? So now I continue on. We intend to show, ladies and gentlemen, that the slope, the hill that these people went on, that they ran to, that they wanted to go to before dinner time, thanks for joining us, was not designated hill to go sledding. We will show that if someone were to ask, where can we go sledding? They were told to go far away from the main house, an area near the golf course. That's interesting. Near the tennis courts, far away from an area that was not covered with obstructions. And that's what happened here. He didn't know it because there was snow covered on the hill, but there was this obstruction. At the bottom of that hill, there was a roadway. And the roadway had railroad ties alongside it. And unfortunately for this guy, he actually hit one of those things. But you'll see later on, if not in today's video, you'll see it in another video where I go through the closing remarks that I made in this case, that this guy was careless, that this guy was negligent, that was my argument, and that he was sledding in an area he had no idea if there were any obstructions. All right. We will show that the hill they were on, that they started to go sledding on, had obstructions, had trees, had stumps, had a roadway at the base of the hill. We'll show that he got on the sled and went down this hill knowing that there was a roadway, knowing all of these obstructions, and knowing that there was a cement barbecue pit a little further on. And yet he disregarded, could you imagine? He disregarded those and went down anyway. What kind of person does that? Somebody who's careless, somebody who doesn't understand that this is important to be careful as you're going and doing a winter sport. They get to the top of the hill, which is in front of the main house, and they go down the toboggan a few times. Now, excuse me. Now you know you can't steer this thing. You just get on, you slide. No problem, nothing happened. We'll show you that they were tobogganing in the same area where the plaintiff claims that this accident occurred. Hey, thanks so much for joining me. Now his wife gets on this pie pan, this dish, this plastic piece of bowl of nothing. That's exactly the words I use, bowl of nothing. Gets on and starts sliding down the hill. 2, 3, 4 times, no incident. No, this is not 4, this is 5. 4 times, no incident. She's sliding down. She goes running back up. She goes down again. Don't forget, raise that objection if you think it's necessary. If you have a question, yell out, objection! Don't answer that question! Okay? We will show that after a certain point, the plaintiff decided that he wanted to get on the saucer too. His wife's having such a good time that he wants to get on this too, never having been on it ever before. We will show that the plaintiff saw his wife go down and saw the characteristics of this saucer. Hey Danny, how are you? Thanks for joining us. Glad you could make it here. This is a reality show called Objection. Don't answer that question. It's about real cases, real lawyers, and real results. So now I'm in the middle of a transcript showing you what happened 26 years ago when I was a defense attorney. And now I'm representing a resort that's being sued by a guy who got into a sledding accident, and now he's suing, we're at trial, and I'm reading my opening arguments as if you are sitting in the jury box. And by the way, if you have questions about what I'm reading, if you have questions about what's going on here, raise the question, and importantly, you could do it by saying, objection! Don't answer that question. Okay? All right. So now, we will show that after a certain point, the plaintiff decided he wanted to get on the saucer. He's having such a good time. I mean, his wife's having such a good time. He wants to get on this too. We'll show that the plaintiff saw his wife go down and saw that it's uncontrollable. He saw that. You can't steer it, you can't brake it, you can't do anything. It just goes. We'll show that the plaintiff had been sledding before. We'll show that he was an experienced ice skater and had been skiing previously to this particular incident and was aware of the general dangers inherent in these types of winter activities. Now, he gets on this sled. He tells his wife, let me have this saucer, I'm going on it. This is a big guy. This big gentleman sitting right here in this white sweater gets on here, gets on this little flimsy plastic dish, sits down and just goes. What's going on in the jury's mind? You're the juror. You're listening to this testimony. You're listening to my opening arguments. What are you thinking about in your own mind? Recreating, imagining what's going on in this beautiful winter resort 3.5 hours away. What are you imagining? You're imagining a beautiful winter resort, beautiful snow area, gorgeous day. gorgeous day, and now this guy decides to grab this sled. A sled, can you imagine? This sled, Rob, thanks so much for those comments. I love it. I really love it. This is great. So he gets on this sled, and now he's going down this hill. And what do you think happens? Okay, the thing starts to spin. It's uncontrollable. It's a flying saucer, and that's what these things are. Not only is it spinning, which he can't control, we'll show that he couldn't even see where he was going. He's looking up, his back is facing down the slope, he's going backwards. And we'll show he didn't know where he was going, didn't know what he was doing, couldn't do anything about it. And that this was solely a result of his own negligence, his carelessness, of him disregarding any risks associated with the sledding. We'll show that it's unreasonable for this person to have gone sledding on this hill. Don't forget, yell out, objection! Don't answer that question if you have a question. We'll show that there was no employee, anybody associated with this hotel, with this country inn, who told him to go sledding at this hill because it was not designated as such. It wasn't a proper place to go sledding. You want to go sledding? Go all the way out there where there's a proper place to go sledding. Not shelling, sledding. We'll show that this person voluntarily engaged in an activity involving a risk of harm, that he had taken the sled without anybody's permission, and he was sledding in an area that he should not have been in. Now, I'm going to stop here for a moment, and I want to tell you about a strategy that I used during this trial that got me in a heap of trouble. I got in so much trouble for doing this. I wanted to go, now you should know that the injured person here, the plaintiff, did not have this sled that he was injured in. He didn't have it. It wasn't his. He didn't own it. After this accident, he gets treated at the hospital and then ultimately goes home, and that's the end of it. And he never knows what happens to this. And I asked him during his pre-trial question and answer session, known as a deposition. I said, where's that sled today? Where's that flying saucer? I don't know. He didn't know. He had no idea. Okay? So welcome. Thank you for joining us today. This is a video about real people, real results, and real cases. Unbelievable reality show. And over the course of this series of videos, you're going to hear interviews with me and other attorneys who are going to go ahead. Rob, thanks so much for sharing. I really appreciate it. Other attorneys who are going to show you what they've been involved in with their cases and take you through actual dramatic moments during their trials, whether it's cross-examination, whether it's opening arguments, closing arguments, something where a witness has lied, something that's better than any TV show, something that's better than any movie, because you're going to hear about the strategies and the understanding of what's going on in the attorney's mind that we want to share with you. I want to share with you. Okay? And so make sure you engage with me. If you have questions, you don't understand why a question's being asked, if you just want to yell out, objection, don't answer that question, then I encourage you to do that. Okay? Do that as well. All right, so let me get back and tell you about what happened during this trial, where I did something that was so outrageous that the judge yelled at me. He screamed at me, not once but twice, and I almost got sanctioned. I almost got held in contempt for doing this. You want to know what it was? All right. So the injured victim here did not have that flying saucer. So what I wanted to do as the defense attorney, I wanted to show the jury what this thing looked like. So I actually made a trip out to Toys R Us, and I went to go look for a flying saucer. And can you believe it? Toys R Us near me didn't have any flying saucers. No flying saucers. How could that be? Everybody has flying saucers, right? You want to have it for your kids. It's wintertime. Well, there was no Toys R Us around that had flying saucers. Hey, thanks for joining. Come on in. So what I did, since I couldn't go ahead and get a flying saucer, I went to my local pizza place and I got one of the pizza pie dishes, you know, those tin things, and I brought that into court. Now, I didn't show my adversary, I didn't show my opponent exactly what this was. Why? Because I knew the moment he saw it, he'd start screaming and yelling and jumping up saying, objection, objection, judge, he can't do that. You see, I wanted to show the jury that what this guy did, this guy was an adult, he was about 180 pounds, 6 foot something. He's sitting on this little kid's toy, this plastic dish. And I wanted to show the jury, now here's where the strategy comes in. I wanted to show the jury that this was an inappropriate toy for this guy to use to go sledding. So I did what I had to do. I now grabbed a sled, not a sled, I grabbed a big pizza pie dish, the biggest one I could find. And now I promised the pizza place, I said, listen, I will bring it back in a couple of days, I promise. So they had a couple extra ones, and this was a pizza place that actually made oversized pizza pies. Thanks for joining me, come on in. And this was a great big dish. So now I had it with my trial exhibits, these big enlargements so nobody could see it. And as I go ahead to cross-examine the injured victim here, the plaintiff, I pull this out from my trial exhibits and I hold up this big pie dish. I say, sir, isn't this what you went down on? And all of a sudden, you should have seen the plaintiff's attorney, the injured victim's attorney, is sitting in front of me at the table ahead of me. He jumps up out of his seat. He goes like this, jump up, and he yells out, objection, judge, objection. He freaks out. That's not what this guy was on. That's not what this was involving. He didn't sit on this pizza pie dish. He sat on a flying saucer. And now the judge turns to me and says, counselor, is that true? I said, yes, judge, but there are no flying saucers available at my Toys R Us. So I brought in the next best thing. The next best thing. Well, guess what? The judge didn't appreciate that because he said I was giving the jury the wrong impression of what this guy, this injured victim, was using. And I said, listen, I know, and I'm telling you right now, that this injured victim did not go down this hill on this pizza pie dish. But it's about the same size, doesn't look the same, but guess what? It's the same concept. It's a big dish. That's it. And the judge says, Oginski, objection sustained. Now what does that mean? It means I can't ask that question. And more importantly, you better put that pizza pie dish away. So now I make a whole big production of it. I pick it up in front of the jury, I make a face, and now I carry it over to my trial exhibits and I put it behind my trial exhibits. And now I go back and continue cross-examining this particular witness. Okay, so where's the strategy here? Well, that's just the first part of the strategy. Hey, welcome, come on in. Come join me. And thank you for being here. You're going to see real cases, real results, and real attorneys better than any reality show. And if you have questions, you don't understand the strategy, or you want to ask something, go right ahead and start out with objection. Don't answer that question. All right, let me take a break for a second. Let me grab some water. All right, we're back. So now, I've now finished. I'm in the middle of cross-examining this particular witness. And what happens next? So now, about 10, 15 minutes later, what do? I decide I have no choice but to pull out this pie dish again. I have to use it as a demonstrative tool to show the jury that this guy was careless, to show the jury that this guy didn't know that this was, not that he didn't know, but to show the jury that this should not have been a sledding device, especially for an adult. For a kid, yeah, it's fine, they can use it. But for an adult, no, no, no. So here's what happened. Let me get some water again, hang on. You should know that when I create these types of videos, normally I get to stop it, I edit this stuff out, but since we're live, you get to see everything. There are no do-overs here, which is great. Later on in the replay, I can go ahead, hey, Michael, how are you again? So now I'm giving a key strategy about what I did with a piece of demonstrative evidence, a big pie dish, pizza pie dish, that was huge, almost as big as a flying saucer. So remember, the judge had told me to put that away, that it was improper to use that. And now during the course of my questioning, I asked this guy again, something about the description. I asked him to describe the flying saucer. I asked him to describe the dimensions. How big was it? What color was it? Were there any handles? Could you steer it? Could you do anything with it? So as he's describing this particular flying saucer, I now turn to the jury. I say, what would be better than to have the actual flying saucer? And he says, I don't have it. I said, well, I have something similar. And I go over, I reach over, and I pull out the pie dish again. And now I start asking him a question. You mean like this? And the plaintiff's attorney is sitting at the table ahead of me. His back is to me. I'm a while back. I am a number of feet behind him. I'm at the end of the jury box near my table. So he can't actually see me reach behind and pull out this pie dish again. But the moment I ask him and I say, "You mean like this?" All of a sudden the attorney turns around, sees it, he freaks out again. He jumps up out of his seat, yells, "Objection, Judge! He can't do that! You already told him he can't do that! You admonished him not to do that!" And now the courtroom breaks out. There's pandemonium in the courtroom. The judge starts banging his gavel. Over and over. "Counsel, stop it." And I'm trying to ask my question. I'm trying to talk over this attorney because I want the answer. And you know what? Actually, I don't care about the answer. All my goal was to show to the jury exactly what this pie dish looked like. I wanted to make the point that this pie dish was something, or this flying saucer was something that this guy never should have been on. Hey, thanks for joining me. So I had to do this. I had to show exactly what went on. And oh boy, the judge didn't like it. He started yelling at me. He started screaming at me. "Counselor, I told you not to do that. Put that thing away. You do that again, you're going to get sanctioned. I'm going to hold you in contempt of court." And I said, "I'm sorry, Judge, but I had to show the jury what I felt was important." He says, "Counselor, don't do it again. If I catch you doing it again, you're going to get sanctioned," meaning I'm going to get punished financially, and I'm going to get held in contempt, which is a terrible thing for an attorney to do, to have happen to. And so now the judge made his point, I made my point, and now that was my key strategy. I simply wanted the jury to understand what this thing was, because without actually seeing it, they're relying on something in their mind, something they may have seen in a movie, in a TV show, something they may have read about in the newspaper. Hey, thanks for joining me. Come on in. So this was an important key strategy. And that's one of the things, that was a key point. That was one of the highlights of my cross-examining this particular witness. And you know what? I think it made a difference in the outcome. And I'm not going to give the outcome away just yet, because I think it's important for you to understand what's happening with the tension and the conflict leading up to the actual result. So I hope you're enjoying this particular video, this series that is going to be the beginning. This is the very premiere, the very beginning series called Objection. Don't answer that question. Using real people, real results, real lawyers on dramatic cases where we pick apart different strategies that are used, where we now show things that are dramatic in the courtroom, where an attorney is using a key strategy during cross-examination, where they show that a witness has been lying or contradicts himself, or we show something interesting, a twist here, a twist there. There's some part of the story that makes it really interesting. So I hope you've enjoyed it up until this point, and now let me jump ahead and share with you. I'm going to share with you the ultimate result in this particular case. The defense was, hey, listen, you were careless. You assumed the risk. And now, because you assumed the risk and you used a device that you should never have been on, you, the injured patient, are the one who's responsible for your own injuries, not us. We did nothing wrong. We did nothing to cause or contribute to your injuries. We were careful. We maintained the property very well. There was no garbage there. There was no obstruction that was put there by someone that wasn't cleared away. It was you, the injured patient. I'm so used to handling medical malpractice cases that I talk about patients so much. It was you, the injured victim. You were the one who was responsible for your own injuries. And you know what? The jury understood. This was a Nassau County jury, a very conservative county, who recognized that this type of activity has inherent risks. This type of activity, you have to be careful. You assume the risk based upon certain activities that you engage in. And there was nothing inherently negligent or careless that we as the resort did to cause or contribute to his injuries. And I'm happy to say, I'm pleased to say, that the jury returned a verdict in our favor, and they did not find in favor of the injured victim here. So now you may contrast that with stuff that I do today. I've been a plaintiff's attorney for 24 years now, okay? And I only represent injured victims, injured patients in cases against people who were careless. And there's a big difference. And I've learned a great deal since that time, since this particular trial that went back, this one was May of 1990. Can you believe that? That's crazy that I actually found this transcript. So this is just an example of some of the types of cases I'm going to be showcasing and highlighting in this new video series called Objection, Don't Answer That Question. So I want to thank you all for joining me in today's live video. You can catch the replay. If you're watching this on the replay and you have questions, you can always send me a private message. You can always pick up the phone to call me as well. You can reach me at 516-487-8207, or you can reach me by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for this morning. I want to thank everybody for joining me, and I hope you have a wonderful day. Take care, everybody. Bye-bye.